Hello, I'm Gopesh and you are watching Legal Bytes. This is our fourth video in the Hindu law series, and the topic for our today's video is the changes brought by the Hindu Succession Act 1956 and Hindu Succession Amendment Act 2005. The learning objectives for this video shall be the survivorship rule under the Hindu Succession Act 1956, effect of exception carved out by section 6 to the rule of survivorship along with two case laws, recognition of the women's property right under the Hindu Succession Act 1956, and in the second segment of the video we shall be talking about the complete abolition of the survivorship rule by the 2005 Amendment Act and recognition of daughter as a coparcener after 2005 Act. Also, we shall be talking about the development in the concept of daughter as a coparcener through three case laws. At the end of the video, there shall be some important questions for pre and mains examination displayed on your screens. Let's now start with our today's video. Prior to the 1956 Act, every property which a male Hindu inherited from his paternal ancestors was regarded as ancestral property. Therefore, it would immediately become a part in the coparcenary property. But after the Hindu Succession Act 1956 came into force, a self-acquired property which a male Hindu inherits from his paternal ancestor would still remain to be a separate property or a self-acquired property in his hands and will not obtain the color of coparcenary property. Thus, after the Hindu Succession Act 1956 came into force, we started recognizing the concept of separate property under the Hindu law. The rule of survivorship, as was there under the old Hindu law, is also incorporated under the Hindu Succession Act 1956. As per the old Hindu law, on the death of a coparcener, his interest in the coparcenary property used to devolve upon the other surviving coparceners. The similar rule has been incorporated under Section 6 of the Hindu Succession Act 1956, which reads that interest in the coparcenary property of a male Hindu dying intestate shall devolve by survivorship. But an exception to this general rule has been incorporated by way of a proviso to Section 6 itself, which contains that when a male Hindu dies leaving behind a class 1 heir or a male claiming through her, then the rule of survivorship will not be followed, and the coparcenary interest of that male Hindu who died intestate shall devolve by way of testamentary succession as provided under Section 30 of the Act or by way of intestate succession as provided under Section 8 of the Act. Let's see two case laws for better understanding the proviso to Section 6 of the 1956 Act. Our first case is the case of Uttam Singh vs Saubhagya Singh 2016 Supreme Court. The facts of the case are there on the screen with the help of a diagram. In this case, there was a joint Hindu family consisting of J, B1, B2. These three are brothers. J died in the year 1973, leaving behind a class 1 female heir, M, his widow. So, the interest of the coparcenary interest of J would devolve by way of Section 6 proviso and not by the general rule as contained in Section 6. In the year 1977, a son SS was born to S. He claimed a partition in the property which S inherited from J, saying that it is an ancestral property. But the court held that the property which S inherited from J was by way of Section 8, therefore it is a separate property in hands of S, and SS cannot claim a partition in it. The points we need to know from this case is that after the Hindu Succession Act 1956 came into force, a male Hindu dying intestate leaving behind his coparcenary interest and survived by his class 1 female heir, his interest in the coparcenary property would devolve by way of Section 6 proviso and not by Section 6 general rule. Also, once a joint Hindu family property has devolved by way of Section 8, the property no longer remain to be a joint Hindu family property, and the heir which hold them would hold them as their own separate properties. Coming to the second case, that is the case of Ashnur Singh vs Harpal Kaur 2019 Supreme Court. And the facts of the case are shown on your screens with the help of a diagram. In this case, there was a person Lal Singh who had large sums of agricultural lands. He died in the year 1951. That is prior to the commencement of Hindu Succession Act 1956. Thus, his property was inherited by Indra Singh by the application of rule of survivorship, and it is considered to be and it is regarded as ancestral property. Indra Singh in the year 1964 effectuated a partition between his three sons, and Dharam Singh had a son Ashnur Singh. What Dharam Singh did was he alienated or transferred his share in the property which he received in partition to his girlfriend. When Ashnur Singh turned major, he challenged that alienation, saying that the property which Dharam Singh received from his father Inder Singh on partition was an ancestral property. Therefore, he has a birthright in that property. And the alienation done by the Dharam Singh for no legal necessity or for no benefit to the estate of the coparcenary was void. The court held that Ashnur Singh had a birthright in the property, thus the alienation done by Dharam Singh was void. The points we need to understand from this case is that when a male Hindu dies, when a male Hindu inherits property from his paternal ancestors, he holds that property in his hand vis-a-vis his lineal 3 male descendants below him as a coparcenary property. And when a property is partitioned, a joint Hindu family is partitioned, it continues to be a joint Hindu family property or a coparcenary property, and the property do not change its character. A major development made by the 1956 Act is that it gave recognition to the women in property rights. Prior to the 1956 Act, women only had limited estate rights. That is, they could hold a property till the time she is alive for her maintenance purposes, and after her death the property used to revert back to the heir of her husbands. Section 14 is there in the Act contains a provision that property of a female Hindu to be her absolute property. Thereby, it enlarges the limited estate possession of a female into her absolute ownership. Section 14 subsection 2 contains a provision wherein where a property is transferred to a woman by way of a will, it would not enlarge into her absolute ownership. This created confusion for a long time. So the Supreme Court in the case of V. Tulsamma vs. Shesha Reddy in year 1977 observed that if a female Hindu holds a possession of a property in lieu of a pre-existing rights, it would enlarge into her absolute ownership and she would hold that property as a complete owner. Now we have come to the second segment of our today's video, that is the changes brought by the Hindu Succession Amendment Act 2005. The first change it brought in was it completely abolished the rule of survivorship. Now, an interest of a male coparcener in coparcenary property shall devolve only by intestate succession or testamentary succession. There is no application or a concept of survivorship now. Also, between 1956 to 2005, the rule of survivorship saw only a very limited application, because when a male Hindu died, he always left behind a class 1 female heir. So the application of proviso to section 6 was always there, and the general rule contained in section 6 was never applied. The major change brought in by 2005 Amendment Act is that it recognized women or daughters as coparceners. The reason behind bringing in this amendment is that before this amendment, women or daughters were excluded from participating in the coparcenary ownership. This acted as a discrimination against women on equality and on gender grounds. Both are prohibited under the Constitution of India. So, to render social justice to women, equal rights to daughters were given in coparcenary property as the sons have. Section 6 subsection 1 of the amended act contains a daughter of a coparcener shall by birth become a coparcener, thereby guaranteeing social justice to women. Earlier, in the old Hindu law, a Kartha used to be a person who was the senior most coparcener in a family. So, since daughters were not a coparcener, this acted as a discrimination or disqualification from their becoming a Kartha. But after the 2005 amendment, daughters are coparceners, so they are also eligible to become Karthas. This was held in the case of Sujata Sharma vs. Manu Gupta, 2016 Delhi High Court. Let's see the development in the concept of daughter as a coparcener with the help of case laws. Section 6 subsection 1 of the Hindu Succession Amendment Act 2005 contains that on and from the commencement of the Hindu Succession Act 2005, a daughter is regarded as a coparcener. So it was interpreted that the daughter would be regarded as a coparcener after 2005. That is, it would have prospective operations. In the case of Prakash vs. Phulavati, 2015 Supreme Court, a 2-judge bench decision, it was observed that the Hindu Succession Amendment Act would have prospective operations and it would apply only on living daughters of a living coparcener, which are there on 9th of September 2005, that is the date of enforcement of the Hindu Succession Act 2005. But in the decision, in the case of Dhanamma versus Amar 2018 Supreme Court, again a two judgment decision, the court observed that the Hindu Succession Amendment Act 2005 would have retrospective operations. That is, irrespective of when the daughter or father was alive or not, a daughter is considered a coparcener by birth. These two decisions are conflicting in its opinion, and both are two judgment decisions. So we needed a decision of a Supreme Court by a larger bench. In the case of Vinita Sharma vs Rakesh Sharma 2020 Supreme Court, a three judgment decision, it was observed that a daughter is a coparcener by birth and the Hindu Succession Amendment Act would have retroactive operations. Therefore, it meant that it would apply on daughters even before the commencement of the Hindu Succession Amendment Act 2005. I hope you liked the video. If you have some doubts and questions, drop down in the comment section. We'll be happy to answer you. And do wait, at the end of the video, important questions for pre and mains will be displayed on the screen. Do like and subscribe Legal Bytes.